go ahead and introduce our other speakers. First off, we have Amy Jenkins. Most of you have had the pleasure of working with Amy at some point. She is CCIA's lobbyist and runs her own advocacy firm, Precision Advocacy. And we've been partnering with Amy for the last several years on all things cannabis policy related. Good morning, Amy. Thank you for joining. And Kristin, who hopefully will be hopping on soon, is the co-founder and board chair of the International Cannabis Farmers Association, and also a board member of CCIA. And I see also joining us is Senator Ana Caballero. So thank you so much for taking a few moments while you're traveling to be able to talk with us about this bill. You are an incredible ally to the industry, and we're super grateful that you put forth this legislation, and really happy that we get to work in collaboration with you. So I know your time is very limited today. I will turn the microphone over to you to say a few words.
Well, thank you very much, Kristin. If it's better for me to turn off the camera because it's moving too much, just let me know. I appreciate the opportunity to do this virtually, and if we get disconnected, I'll get back on again. That was my biggest concern, is that if you know rural California, broadband access is somewhat shaky. So let me tell you about SB 59 and let you know that I'm really honored to be working with the cannabis industry. You've done a tremendous job of taking an industry out of the shadows and following a regulatory structure that's never easy for anyone. And so SB 59 is a bill that would create the opportunity for the provisional licenses and next year. And what we want to do is make sure that those individuals that have already obtained a provisional license can continue through the regulatory and annual license. And we know that this is a new industry. Many of the counties and cities have not been in a position where they had the regulations in place to be able to quickly ascertain whether the business is appropriately placed wherever it is. And because CEQA requires that a review, a site specific.
Oh. Got some audio.
Yeah, the senator, you're breaking up just a little bit, but hopefully we'll be able to get you back. We appreciate you even attempting to hop on while you're traveling. Yeah.
You have to every single line. Oh. Okay. In any case, SB for the local governments to finish their regulatory to move to for the next 6 years. So that's the 6 years to get through the regulatory process. Some may move very quickly, some may take time. So that's number one. Number two is there are a number of organizations, cannabis organizations that have not filed for a provisional license because the county is still putting together the regulatory framework in order to allow that to happen. No fault of their own. They just haven't gotten a provisional license. And we extend that for 6 months to July 1st of next year. Let me just tell you that provision is getting a lot of pushback. And two things. One is that the environmental community is opposed to the bill, some to varying degrees, because they believe that everybody's had enough time, and that's all there is to it. And that what some of the cannabis industry is doing is trying to violate CEQA and to do it without getting a license. It's misplaced. It's not based on any reality, I believe. And so we're in the process of negotiating details. They want an extension for 2 years. We don't think that's enough time. So right now we're at 6 years. We got it out of Senate EQ, environmental quality, I'm hoping we can get it over to the assembly the way it is right now, so that we have an opportunity to work over there as well. And the provisional license, what we're trying to do is to find the sweet spot. We need to ensure that if people want to come into the legal market, that they can, but then shut down those that have no interest and that are doing the illicit grows in particular, because we're hearing stories about stream bed alterations and things that are not good for the environment from people that really don't intend to legalize their operations by going through the regulatory process. So a lot going on. I want you to know that we have a great team that's working on this, and we're going to continue to work on it. And I'm prepared to answer any questions if there's someone who has one. At least I'll try to.
Lindsay, you're on mute.
muted.
Thank you. If folks would like to submit any questions, please do. I know we're really grateful for the senator's leadership on this really important issue, and we lost a little bit of the audio there during your travels, but I think, you know, to stress the importance of the provisional program and what it has meant to you know, folks trying to become compliant in the industry, it's been incredibly crucial. And we know that you know, helping the folks who are in the provisional program currently is one of CCIA's biggest priorities, and I know is important to folks throughout the industry. So we're grateful for your leadership, Amy. I don't know if you would like to add anything, or Kristin. I know we only have the senator for a few minutes, so want to be strategic.
No, I think, you know, we appreciate the senator's comments. It's always good to see you, Senator Caballero. And, you know, this is, you know, I think as you highlighted, this is a very challenging issue. And I think trying to balance the interests of the industry and the environmental community and identifying that sweet spot is, I think, what we're all committed to working on. So we're just honored that you have agreed to take such a challenging issue on, and it's been a pleasure to work with you and Peter. So that the way we're going to walk through the day, or the remaining time, is we're going to do kind of a step-by-step history of the provisional license program. We're going to talk a little bit about CEQA, what's taking so long, and then talk about next steps. So that's kind of the agenda going forward. So I don't know, Lindsay, if any questions are coming through at the onset now, but you are welcome to stay on and participate in that conversation as long as you like. So.
Absolutely. Thanks, Amy. We actually did have a question come in. Can the senator speak on social equity applicants and how the provisionals apply to them, essentially, I guess, within that 6-year extension?
Yes, so we do not constrain the equity applicants. We leave it up to the local governments to define what the equity applicants are in their community, and then to set up a program to be able to make sure that they can enter into the legal marketplace. We want to make sure we're giving them maximum flexibility. And part of that is because we part of the equity is that it's very expensive to move into a regulated industry, and so it's going to take resources, and it's going to take them a little bit more time.
Great, thank you for that. Next question is, how can the industry best support SB 59 at this time?
You know, I think the best way to support it is to talk with your local legislator and have real specific examples of some of the obstacles that you've had to face. We had as a witness for the hearing a supervisor from Mendocino County who was excellent. And he basically went through the whole process of how many departments, how many regulatory agencies are weighing in on these licenses. In other words, you do the application with the county, but then that application has to move through a number of county and statewide organizations that have to approve it before it becomes final. And that was really helpful. I think the more that you can educate your local legislator, and then if you could let your organization know who you've talked to, that would be real helpful for us, because I'm going to be making the same contacts. And if I know you've already done it, that's really helpful.
That's great. Thank you. And I know too, CCIA has done a huge, massive call in all of our committee meetings and all of our membership meetings for support letters for SB 59. I think there's probably about 60 of them that we've helped usher in from our members. So that's another outlet to issue support for the bill.
That's great. That's
Yeah.
wonderful.
Thank you. Next question is, does the 6-year extension only apply to equity applicants, or does it apply to existing provisionals as well?
No, it's all provisionals. That's where we started from, is that it's all provisional licenses get extended for 6 years.
Great.
And you know, one of the discussions we're having with some of the environmentalist groups, as well as labor, because labor has weighed in opposition to 6 years, is that there's a concern that if you have a provisional, then you'll wait and you won't do anything during that period of time. I don't believe that's reality, but what we may want to do is set up some milestones that show that there has been activity, and that if there are problems moving from the provisional to the annual, that they're outlined as part of the plan, that it's not the operator's fault or the licensee's fault. It is maybe local government, or, you know, who knew we were going to have a pandemic? So that just really created uncertainty and the lack of opportunity for the on-site reviews that are required by CEQA and by some of the permits.
Yeah, for sure.
Yeah.
Well, thank you for the questions, folks. Continue to submit them through the Q&A function of the webinar. We're very grateful for the time that you've spent with us. I know you have a very busy day. We'll see if we have any more questions that pop up. If not, we can go ahead and start the presentation. And we can let you move on with your day. I know you've got a very busy schedule. Great. Well, if we head over to our PowerPoint presentation, we can start off. We're going to talk a little bit about the history of provisionals and CEQA, and both Kristin and Amy are going to walk us through where SB 59 stands currently, and where we think it might be headed. So I'm going to turn it over to Kristin Nevedal, who is co-founder and board chair of the International Cannabis Farmers Association, to lead us through the first couple of slides. And I'll try to weave in folks' questions throughout. And then also we will have an opportunity to do a bit of Q&A at the end.
Okay, great. Thanks so much, Lindsay. So I think we can go ahead and go to the first slide. This is Kristin Nevedal, and so thanks everyone for joining us today. In addition to serving on the ICFA Board of Directors, I also have the pleasure of serving on the California Cannabis Industry Association Board of Directors. So it's a real pleasure to be here. So let's get started and talk about provisional licenses and the general criteria. So cannabis licensing authorities under the provisional program may, at their discretion, issue a provisional license to a commercial cannabis applicant, so long as the annual license application is complete. So just to speak to that, same application process for everyone coming into a state license. It's whether or not you're issued a provisional or an annual that is the difference. So you complete the standard annual application process, and if you aren't ready for an annual for a number of reasons, you can be issued a provisional so long as an applicant you can demonstrate that you have local authorization. And that can be a temporary authorization so long as you can show evidence that your compliance and meeting your full local permitting requirements is underway. And then secondly, the provisional license requires that you can show as an applicant that you're in progress in meeting the California Environmental Quality Act compliance, affectionately known as CEQA. So those are kind of the two main components here. For those of you that are cultivators, it's probably worth noting that the application requirements most recently for cultivators was upgraded to required what CDFA is calling a signed draft agreement for the Lake and Streambed Alteration Agreement. That really means that you as an applicant have finalized your negotiations over that agreement and signed it, and then are uploading that into the application portal as a new provisional applicant. and that you're sending that off to CDFA for them to finalize the execution of that agreement. So not noted on the slide, but that is a new requirement most recently for cultivators. Provisional licenses, like annual licenses, are valid for 12 months and may be renewed, suspended, or revoked at the discretion of the licensing authority. And they basically cancel as you transition into an annual license. So you don't have to reapply essentially to move from a provisional to an annual. What we generally see is during the renewal period, the licensing authorities are working with the applicants to try to get them transferred from that provisional into an annual status at the time of renewal. So I think we can go to the next slide, please. Thank you. So a little information about the California Environmental Quality Act, or CEQA. So CEQA is a set of laws and rules that require state and local government agencies to inform decision makers and the public about the potential of environmental impacts that might be brought about by proposed projects. Now, project is bolded in this slide and probably throughout the presentation, simply because when you are an applicant to stand up any kind of business, there's a difference, kind of code words in regulatory frameworks between activities and projects. So cannabis was determined to be a project by the state. So all projects really are subject to a discretionary process and require project-specific CEQA analysis. So the analysis conducted under CEQA is really to ensure that the activities that that project is going to undertake do not result in significant impacts to the environment. So you have to show findings that your project, when it's operational, will have less than significant impacts to the environment. And through that discretionary permitting process, mitigations may be applied to your project application to ensure that you can meet less than significant impacts to the environment. So let's go to the next slide, please.
Hey folks, Kristin, I'm just going to hop in here, encouraging folks to submit your questions only through the Q&A portal. We're not going to have an opportunity for participants to raise their hands or comment. Do it all through the portal and we'll try to weave the questions in. Thank you.
All right, thanks for that, Lindsay. So looks like I got a little ahead of myself with the last slide, but just to reiterate, a project really requires a discretionary permit action to take place. And so they're kind of an interchangeable component. Anytime something is declared a project by a public agency, whether that's a local or a state agency, it requires a discretionary permitting action to take place. And likewise, any discretionary permit or license action means that that activity is now elevated to a project level. And so projects can be a couple of different things. It might be your individual private business that you're trying to get authorized locally or at the state level, but also the term project can be applied to an agency, whether that's a local public agency or state agency, because new rules and regulations that are set up by public agencies constitute a project. Therefore, those new rules or regulations are also subject to CEQA analysis. Let's go to the next slide, please.
Kristin, just really quick, there was a question that came in a bit earlier about defining how do we define significant when we're talking about a project. I don't recall you address that, so I'm just wondering if you need to maybe define that a little further, or you can comment on that piece.
I think that's hard to define because when we're looking at less than significant impacts, it's an analysis based on around 21 different environmental criteria. And then it's usually defined against a baseline. So the baseline for cannabis is generally the local environmental impact report. And if the local jurisdiction, say, utilized the local jurisdictional CEQA exemption, which has allowed local jurisdictions the ability to adopt an ordinance without having a CEQA analysis of that ordinance, so long as that ordinance only issues discretionary permits. That baseline is a little more elusive for determining the threshold from less than significant to more than less than significant, right? So this is a tricky conversation here. In that instance, it's generally recommended that the reviewing agency, whatever agency is reviewing that application, look to the state's environmental impact report to try to comb some baseline criteria out. In the instance where a local jurisdiction does a CEQA analysis of their program, their local ordinance, that CEQA analysis would become the baseline, excuse me, for less than or more than less than, right? It would create that baseline for the less than significant impacts. So I hope that that helps. It's not a conclusive answer because it's site specific and then jurisdiction to jurisdiction based on what sort of analysis they've conducted. So Amy, were there more questions along that line or should I continue?
There's quite a few questions coming in. I don't know if we could answer all of these, but you know, Dale is asking about the average cost of getting a CEQA EIR and for a cannabis specific project. I don't know if we can quantify
I think that that's really a good question, but I think that it again is project specific because if we're looking at, say, cultivation, the cost of an EIR associated for a cultivator who is, say, on flat land and cultivating in a location that has had a history of crop production, so it's already disturbed soil. There's not a lot of concerns about sensitive flora or fauna, perhaps. You don't have slope issues. The cost of that kind of analysis in that setting is often much less than the cost of analysis, say, if you are trying to conduct cultivation in a wilderness area that's a little more remote, that might have slope issues and more prevalence of sensitive species, because now you're starting to get into having to do a series of biological and species studies. So that can quickly bring the cost up. And I would say that depending on, and then if you're in an impacted watershed, right, you might be elevated in cost even more. So I think they can range anywhere from, say, 10K upwards of 100K, depending on the circumstances around your project and the location that that project will be landing when it's approved. So.
And I'm happy to track some of these questions and see if we can't tack them on at the end to a Q&A, so we can just make sure to cover what's in the presentation and then we can hopefully circle back. So continue to send them in, folks. Thank you.
Okay. And I'll just move on. So who determines if a private activity is a project? Well, that's really up to the lead agency. So in the case of cannabis, the lead agency is defined in statute for all things cultivation as the California Department of Food and Agriculture. But what we saw translate from statute into the regulatory structure is that the state licensing authorities have determined that all types and scale of cannabis licenses, annual licenses specifically, are projects and therefore subject to project-specific CEQA analysis and compliance. So, you know, commercial cannabis applicants at the local level, it's a little challenging because while that's a requirement at the state level for project-specific CEQA analysis, the agency responsible for conducting that analysis usually defers to the first agency to issue a discretionary permit or action on that sort of a project. Largely this is taking place at the local level, but in the case where we have some local jurisdictions issuing ministerial permits, it's been a very bumpy road for applicants transitioning from provisional to annual. So it can get pretty challenging and convoluted. But where we are today is that the state has determined that all annual licenses are projects and therefore subject to project-specific analysis. Let's go on to the next slide, please. So have commercial cannabis licenses been allowed a CEQA exemption? Well, that's a big fat no. There's not a CEQA exemption available for the actual applicants, not in statute. So the only CEQA exemption that has been available in statute has been in relationship to the local jurisdiction. And I mentioned it briefly, but we'll repeat it here. So under Business and Professions Code 26055 subsection H, local jurisdictions are exempted from having to conduct CEQA analysis when adopting a rule, regulation, or ordinance, so long as that rule, regulation, or ordinance issues discretionary permits to the cannabis businesses that they're standing up that ordinance for or included in that ordinance. This ultimately defers the CEQA review directly to the applicants in that process. Because remember, any discretionary permit that you might receive, regardless of whether you're a cannabis business or a non-cannabis business, is going to fall or trigger CEQA analysis. So ultimately, section 26055H does not exempt anyone in the supply chain from CEQA analysis. It simply exempts the local jurisdiction from conducting that analysis of their ordinance. Now, this might be a little bit confusing because when you go through a CEQA or a discretionary permit process at the local level and you complete that process, you're going to be issued either a notice of exemption or a notice of determination. And so that notice of exemption that you are issued does not mean that you're exempt from CEQA. It means that you have undergone a project-specific review that allows the local jurisdiction to justify that you're qualify for a notice of exemption because you're conducting a like activity, right? So you're a dispensary in a commercially located or commercially zoned property. And so under the analysis of your project, they determined you qualify for a notice of exemption, but you still went through that CEQA process. So I hope that helps to clarify. Let's go to the next slide. So why so many provisionals and so few annual licenses? I think this is really a timeline issue. It takes a local jurisdiction an incredibly long time to process a discretionary permit, generally 7 to 15 months if they don't have a significant influx of discretionary permits to review. So for example, a single planner working on a discretionary permit and running it through the system on a local level is only going to be able to process around 5 to 7 discretionary permits a year. So this timeline really has to do with how many planners you have in your local jurisdiction's planning department, as well as how many use permits or discretionary permits are coming through that department. So I think prior to cannabis, most planning and building departments could process, depending on their staffing size, someplace between 20 and maybe 50 on the high end a year discretionary permits. But in some local jurisdictions, we have hundreds, if not thousands, of cannabis permits that have been added to the queue of discretionary permits that these local planning and building departments have to process. And that has created an incredible bottleneck and backlog. So what we're seeing is in a lot of places with high volumes of cannabis permitting being added to traditional permitting, we're looking at 2+ years. So Humboldt County is a great example. Humboldt County has 14, and that might, drop a little bit depending on turnover, but generally they house about 14 or keep about 14 full-time cannabis planners employed, and they are able to process 70 permits a year for cannabis. So, and we have, I think we had somewhere close to 2,000 applications that came in originally. Some folks have dropped out of that system, but we still have hundreds that are in the queue for processing here. So it does take a while to get through it. Let's go ahead and go on to the next slide, please. So how long does it take to process a provisional into an annual? Well, again, this takes depends on the local jurisdictions. The local jurisdiction has to wrap up their permitting analysis and make sure that the applicant has a fully authorized permit with some sort of CEQA notice on it, either a notice of exemption or a notice of determination. So when all of that is done at the local level, the state can start their processing or transition of your provisional into an annual. So you have to go through an administrative review, which usually takes the licensing authority a couple of months to manage, and then a scientific review where they look at not only the property and premise diagram, but if you're transitioning, they're going to look at the depth of review that was conducted by the local jurisdiction that warrants their issuance of your notice of exemption or notice of determination. So they might analyze the staff report and or subsequent materials that the local jurisdiction put together before you say went to hearing with planning commission or zoning administrator. Ownership qualifications, they're going to re-review that and make sure that no amendments are necessary, which might take another 2 to 4 months. And then any deficiencies that are brought about or brought to their attention during all of those steps of review might add additional months depending really on the applicant's ability to turn around and correct those deficiencies. So minimum timelining for processing an annual, should you have all of your local ducks in a row, is about 4 to 11 months. So thanks so much. I'm going to hand it over to Amy, and she's going to talk about the legislative components. So Amy, the floor is yours.
Thank you. I was emailing back and forth or texting back and forth with Peter Ansel, and I want to make sure that everybody who's on this knows that Peter Ansel has also joined our conversation today. He is one of the chief consultants for Senator Caballero and is the lead staff person that we've been partnering on and helping to shepherd SB 59 through the legislative process. So I will go ahead and provide some context here, and then also welcome Peter to chime in at any point in time. It's been quite a partnership so far, and so I kind of see it that way throughout the slide presentation. So just beginning on my end with the background on the provisional license program. So I'm sure as many of you or all of you know, when the commercial cannabis program took effect, January 1, 2028, the expectation was that the industry was not necessarily in a position to meet and achieve all the requirements necessary to obtain an annual license. And so there was a temporary license path developed. If I'm not mistaken, I should know this, it was a 4-month, and then there was the option to extend twice to issue additional temporaries. And the idea was to onboard folks and get them into the annual system. What ultimately happened as we were watching this process unfold is it was determined very early on that additional time was going to be necessary to effectively onboard existing operators and ensure they met all of the licensing requirements, including CEQA. And so actually, this came out of conversations with CCIA, the County of Monterey, and the rural county representatives of California. We came up with SB 1459. And so what this essentially did was officially establish the provisional program. It was essentially a 1-year extension of that program. And we thought that would be sufficient time. So fast forward in 2019, as we were beginning to see the conclusion of the provisional program, we again did an evaluation of existing provisional license holders, what the status was. Obviously, we saw again, that we were not onboarding applicants and getting them into annual licensure. And so we moved forward with a new bill, AB 97, And this originally, when it was drafted, it actually did not include an end date. It extended the provisional program for an indefinite period of time. And so that was kind of the original idea. And then subsequently, there was significant pushback by the legislature amid fears that extending the provisional, absent some critical milestones for achieving CEQA compliance, it just was a non-starter. So the timeline very quickly was reduced. First, we were proposing a 10-year timeline until 2028. That got ratcheted down to a 5-year timeline. And then ultimately, through our negotiations, we were only able to get a 2-year extension, which really brings us to where we are today. The opposition, as the senator noted, even in her initial remarks today, largely came from the environmental community. There was also significant concerns expressed by members of the legislature, primarily on the assembly side. There were essentially 12 Democrats that in the assembly that caucused and upheld or essentially barred moving that trailer bill until we ultimately got to that 2-year consensus. And I mention all that because it really speaks to the challenges associated with the current negotiations. Many of these individuals are still in the legislature, some are now in the Senate, and are really concerned about the provisional license program and this timeline, and we'll spend some time talking a little bit more about that in the end. But next slide, please, Eddie. So in looking at where we are today and what ultimately prompted the introduction of SB 59 are these current statistics, which are very alarming. And in fact, they've gone up since our original conversation with Senator Caballero's office back in the fall. We were looking at about a 72 to 75% provisional percentage, at least of existing provisional license holders. The statistics have actually gone up since March of this year. So I should have credited, and in case he's on, I'm sorry, we'll update the presentation, but Marijuana Business Daily actually did a PRA and was able to get the updated data, which John Schroyer, the reporter, very generously shared with us, saved me a little time. So as of March, we're now at 83% of the legal industry is under provisional license status. And to show you the breakdown, it's 79% Bureau, 66% Cannabis Manufacturer Safety Branch within the Department of Public Health, and then 85% within Cal Cannabis Cultivation Licensing within the California Department of Food and Ag. So the statistics are alarming. And I think, Kristin's thorough background of the CEQA process is obviously contributing to this substantially, which, again, is why this legislation and getting this extension approved is absolutely essential to the viability of the licensed industry. So we'll go ahead and move forward to the next slide, please. Thank you. And so as Senator Caballero indicated, we approached her office. Actually, it was by happenstance. Peter contacted me about briefing him and the senator on some emerging issues so that she could talk to some of the licensees in her district. And when we explained the provisional program and the need for an extension, she immediately indicated that she wanted to be helpful. And so we went ahead in partnership with her office and introduced SB 59, as she mentioned earlier. And we knew we were casting a wide net. That was really the intention at the beginning, so that we could engage in negotiations with various stakeholders and see where they were at. So the bill was introduced very broad. We knew we were going to have to ratchet that down, but we wanted to use it as a forum to engage both the cannabis industry, the local governments, the environmental community, as well as the administration and the licensing entities. And so that was merely the starting point. But what we did is the original introduction was a blanket extension of 6 years, which included the jurisdictional CEQA exemption component, and then the 6 years for the program. And the original language would have allowed for new provisionals through the entirety of that 6 years. And that was the bill as introduced. So then as we began engaging in a series of conversations, it then became very clear to us that as we expected that we were going to have to narrow the bill substantially, which brings us to where we are today. And I would imagine that will prompt some discussion as part of the presentation. So next slide, please, Eddie. So the bill was amended, I believe, I want to say it was April 20, well, it wasn't April 26th. That's when the hearing was.
I think it was
bill
the 12th. The
Thank you.
12th.
The
Yep.
bill was amended April 12th. And this was the product of, again, some pretty robust discussions that we have been having. And Peter can certainly chime in and highlight those discussions, but they have included conversations with the licensing entities directly. It has included conversations with the environmental community, with the industry, with local government stakeholders, as well as others. And so evaluating those discussions, and then also working through the policy committee process, because the policy committees also had their opinions on the direction that the bill needed to go. This is where we landed, and this is the current version of the bill as of today. So what the bill does is it allows the licensing entities to continue to renew provisional licenses for all existing provisional license holders for the entirety of those 6 years. So through January 1, 2028, or until CEQA review is completed, whichever is earlier. The other thing that's not in here, but it's just a point that I want to raise, is that there's also language embedded in that particular renewal section that says if you were ever in a possession of a provisional license for a particular premise, but that provisional license either expired or it was suspended or revoked, there is the opportunity to apply under the 6-year time frame. So if you lost your provisional license for whatever reason, you could submit an application for that particular license again, since you had a provisional previously. So that is embedded in the language. For new provisional license holders, and this is probably the most controversial element of the bill as currently written, it only extends the provisional license timeline for new applications for 6 months, with the conclusion of that being July 1, 2022. So basically any new applications would have essentially a year come this July. So to achieve or get into the provisional license system. And then once in, you are eligible for 6 years, or theoretically, I guess, 5.5 years, depending upon the timeline, but you would have some additional time to get into annual license status. Now, a question came up earlier today about the social equity components and just outlining some of the costs and impediments associated with getting into compliance and obtaining a license. And that was really important to Senator Caballero. And we also recognize that social equity and promoting social equity and advancing social equity is a very strategic, important public policy goal. It was in Prop 64. We've had subsequent legislation. And so we do, the bill does provide a 6-year pathway for social equity applicants. And so if you are a social equity applicant and you are in a social equity program in your local jurisdiction, you would qualify or be eligible to apply for a provisional license within that 6-year timeline. And if I'm remembering the prior question correctly, there were concerns again about the costs of getting into the system. So the idea with this is that you would be able to obtain a provisional license while you were undergoing environmental review. And so you could commence operations, and the thought is that you would obviously be able to generate revenue as a license holder, provisional license holder, which would help defray some of the costs associated with achieving full CEQA compliance, as well as all the other requirements associated with obtaining your annual license. So that, but I want to talk a little bit more about that in just a moment. And then obviously the final piece is the provisional program then will repeal January 1, 2028. So this is currently, again, what is in the bill. I want to stress, and I think, and I also want to give Peter an opportunity to weigh in. There are still ongoing conversations about this bill and, what the final product should look like. And I think there's still some room for additional modifications, and we'll talk about those in the next 2 slides. But conversations are ongoing. So actually, let's go to the next slide, because I think I elaborate on that a little bit more. It's hard to remember. So, okay. So just looking at this next piece here. So we did get the bill out now of 2 policy committees. The first was Business and Professions Committee. It passed unanimously. We had every indication that it would. That is a very friendly committee that is very focused on trying to ensure pathways for the cannabis industry. So they approach cannabis policy with this, with the perspective of again, wanting to provide a pathway for operators to enter the legal system. The bill then went to the Senate Environmental Quality Committee, and that committee is charged with ensuring that businesses are meeting and complying with the state's rigorous environmental review processes, so CEQA. And so they reviewed the bill under that lens of trying to ensure adequate environmental compliance, which is largely what prompted the amendments that I just went through on the prior slide. When that bill passed out of the Senate Environmental Quality Committee, it passed out with a lot of comments raised by the legislators who kind of deem this as an ongoing conversation. I think the chair framed it as a work in progress, because again, I think there is a real sensitivity to, again, not wanting to
Amy?
Hey, Amy.
Amy, we're losing your audio a little bit. Can you check your mic?
It's only me at my house right now, so I apologize.
Yeah, you went quiet. Maybe mute yourself and we can try to. Go again, Amy. Does that?
All right. Can you hear me?
Yeah, that's better. Yeah.
I apologize. Geez, and it's just me today.
Well, we've had some issues getting this thing off the ground today. So
I
it's par for the course.
apologize. Well, I'll just say, again, I think we're trying to balance the various interests of all the various stakeholders involved. But there, I think most see this as well, I guess I would say we've got opposition on one side, we have opposition on the other side, and we're kind of finding ourselves in some respects in the middle. And I really welcome and appreciate the work of Peter and Senator Caballero's office in striking the appropriate balance between meeting the needs, meeting the expectations that this was supposed to be a temporary program, while ensuring licensees have a path, or operators have a path to enter the system. And just finding that right balance. And I think that's kind of where we are in a lot of the negotiations at present. Peter, do you want to add some comments?
Yeah, I think the only other thing I would add is, there's a dynamic that relates back to Prop 64 and some language that was put in at the will of the voters that makes just changing the way that the cannabis industry and CEQA interact, making changes to that difficult to do. And, while it seems like that would be an easy thing to try to fix in the bill, the experience of working on anything that looks like a CEQA streamlining bill or a CEQA exemption bill in the legislature, especially on something that's so important around keeping licensed businesses licensed going forward, there's a real risk of trying to fix the CEQA parts inside of this bill. And so we've been, we think pretty smart to acknowledge the fact that there is, some tension there, and that the way the cannabis industry complies with CEQA is different than like-kind businesses, whether that's on the cultivator or the retail side. but that fixing that is likely a more positive discussion outside the constructs of trying to ensure that the licensed industry stays licensed. And so, it's a challenging dynamic in the bill, but one that we can't just probably find an easy solution to and fix inside the bill. So I hope everyone understands why we don't do it and try to do this inside the bill. But that what Senator Caballero is really focused in on is ensuring that people that have stepped into the legal licensed marketplace have a pathway to get to annual licensure. And as a former secretary of Business Consumer Services Agency, she understands the need for businesses to be able to plan and for how they interact with the state, and to assure, have some certainty that they have with state regulators, a known pathway to be able to conduct business. And so that's where I think we're trying to take an incremental step forward in 59. Thanks.
Thank you, Peter. And I think to that point, we are continuing to explore some additional amendments to the bill. And so I think those are going to be some ongoing conversations. One I'll just mention, and it was on the previous slide, but keep it here. It's fine. But one of the things that Peter and I are trying to explore is with our partners and with the administration is some additional assistance. So whether it be technical assistance for local governments to process applications in a more timely way, or whether we can explore technical assistance for provisional operators and equity applicants. So we are looking at various funding opportunities. Other discussions that are occurring relate to milestones, both for the licensing entities and for the applicants, so that applicants know what the expectations are when they apply, whether we can establish a timeline, whether we can establish a little bit more clarity as it relates to that process. So those are things that Peter and I and the broader coalition are discussing as ways to provide additional support so that we can get through the process, the rigorous process that is required in law, and get folks onboarded into the annual license system. This is the last slide I'll mention, and I think it's a really important one, and it's a conversation that has not been included in this discussion about the bill and provisional licenses, and that's really future discussions. And I think the way that CCIA and ICFA are really looking at SB 59, and I think Peter alluded to this, is the fact that the key point of that bill is getting this provisional program extended. That is the most important thing I think we do as an industry this year, so that our existing operators are not in a position of falling out of compliance. But what I do think that this should lead to, and I know that the CCIA board and the ICFA board are very, very focused on this, is how do we address CEQA process flow going forward? And I think that is going to really become a much more robust discussion, but we need to get that provisional extension first. I mentioned the timeline piece also as part of that conversation, whether we put some milestones or benchmarks into the bill, or we continue those discussions as this bill moves. But we're really trying to do a lot of this simultaneously, though the CEQA process flow will I think accelerate as we get closer to agency consolidation. And we'll continue to have those discussions, and I expect more webinars on this subject.
Mm-hmm.
The last thing I would be remiss if I did not mention due process. We do have a number of folks even on this webinar that have expressed a lot of interest in identifying a due process mechanism for provisional license holders. And I want to say that the association is very sensitive to that issue. And those are conversations that we are also exploring. However, putting a due process component into this bill would further complicate the viability of this bill. This bill has an uphill battle, but we are very sensitive to the critical importance of having some additional due process for provisional license holders. And so we are very committed and are engaged in conversations and exploring that issue with the legislature and the administration.
That's great. Thank you, Amy. Well, we have a few minutes left. If we've got a couple existing questions here that I'm going to try and get through. I think the main takeaway that we really want to stress is that SB 59 is incredibly important, and that we need to continue to keep making sure collectively as the industry that this bill moves forward. It was alluded that we have opposition coming in potentially from labor. We have opposition from environmental groups, certainly around trimming that 6-year kind of processing of the provisionals that are currently in the queue. And so we really need to make sure that we stay focused on what the industry can move forward with. So this is not going to be the last webinar that we have on this issue. So there was an interesting question that came in before about what prompted this newly intensely impactful provisional license requirement to have a negotiated applicant sign an LSAA draft agreement? And Kristin, maybe this is directed to you. And essentially that would close the door to small operators entering into cultivation licenses. Can you maybe talk a little bit about that? And then we'll see if we don't have time for one more.
Yeah, my response is speculative because I wasn't in or I didn't participate in the negotiations between the California Department of Food and Agriculture and the California Department of Fish and Wildlife. So I know that in statute, they are somewhat tied together as far as how CDFA engages in regulatory development. So they have to essentially have the blessing of California Department of Fish and Wildlife and the Water Board. So they're a trifecta in rulemaking when it comes to cultivation licenses and basically all licenses related to Cannabis. So I mentioned that those were lengthy internal deliberations about what is required and should be required for a provisional license versus an annual license. And Fish and Wildlife has expressed frustration, similarly to applicants expressing frustration around the Lake and Streambed Alteration Agreement process and its adoption. So I suspect it was a result of long-term frustrations over the number or the prevalence of adoption. Now, as far as how it impacts small farmers, I think it probably impacts folks in Region 1 the most, to be honest with you, because there's quite a significant backlog of draft or notifications for Lake and Streambed alteration agreements in Region 1, which is where we do have a lot of small farmers. So for those of you not familiar with the reference to Region 1, it's basically the North Coast, northern portions of Sonoma, all of Mendocino County, Humboldt County, portions of Trinity. So this is a high numbers of small legacy cultivators. And Fish and Wildlife has been incredibly backlogged in moving those Lake and Streambed alteration agreements forward here. Having the signed draft is you're right, it's going to be challenging for farmers in this area because the timeline to achieve that could really essentially make or break the ability to get a provisional license in a timely fashion to continue cultivation if you don't have a provisional license already. So I think I'll leave it there, Lindsay.
Thanks, Kristin. Appreciate that thoughtful answer. We'll try to sneak one more in. Will this bill prevent existing license holders from opening additional new locations? I would think no, but
Yes and no. But that's also why the CEQA process flow conversation is
happening.
Important. So yes, it will close the door for new provisional licenses, and that is really that is the most challenging part of this conversation, is that in all of our communications with the administration and the legislature, this program was supposed to be an onboarding for existing operators, and it was supposed to end. So we are trying to move the bill. If we can get a longer timeline. I think we're all amenable to that, but we need to protect those that have provisional license status. We believe that's the biggest priority right now. But yes, it would make expansion more difficult after July 1, 2022, which is why I said the CEQA process flow is going to be absolutely essential to addressing. There's, in my view, and this is just Amy Jenkins talking, but in my view, there is no reason why every cannabis license holder has to go through a comprehensive CEQA review process. And those are conversations that we are having with the administration and frankly have been having them for months now. The comprehensive environmental review that is required should be reevaluated. And so, and what we have been told by the administration is that they concur. So we are trying to work through, with the idea being that we can end the provisional program and work towards a streamlined annual license process that does not take over a year or 2 years to get into. And so that's the second phase of this conversation, and will probably be, you know, obviously we have a board, but my guess will be one of the CCIA board's biggest priority, if not the priority for work next year.
Agreed. Well, we are just a couple minutes over. I know there's still some questions here. I will certainly pass these on to the panelists and we'll share them with Peter in the senator's office too. Really appreciate you, Peter, hopping on, and thank you for helping to coordinate the senator's schedule with us this morning. I know she's incredibly busy and we were happy to have her on for a few moments. And thank you to Kristin Nevedal and to Amy Jenkins for leading this conversation. We hope to see everyone back here on our next go around and doing a deep dive onto SB 59 and CEQA process flow. And we hope you all have a good day. Thanks so much for joining us and supporting CCIA.
Thank you, everyone.